And welcome to Recovery Report Live. I'm Dan Odess, president of GlobalPro, where we manage risk to recovery, and we have managed more than $1 billion in recovery. We are your one-stop shop for all your policyholder needs, whether you're a business owner or a community association. We make sure that you have the insurance you need and that you're recovering the way that you should. And we're also up in Tallahassee and involved in the Texas legislative sessions, making sure that your voice is being heard as consumers. Why? Because there's a lot of changes going on right now as it relates to anti-consumer legislation that sadly is impacting the way that you recover and the value of the product that you are purchasing. In many ways, not in a good way. And so sadly, we continue to track these things, and there seems to continue to be this move towards protecting the interests of insurance companies, allegedly attracting them into the markets. And then the same legislators do an about face and then tell us how it's not going to make any impact at all. It's not going to save you money. It's not going to make the money more competitive. And they continue to do these things. And we are in session right here in Florida as well as in Texas. I know that we had our very own Rob Bowlby that was up there in Texas doing his thing, talking to legislators, as well as here in Florida. We were doing just the same, and we continue to do it. And we continue to advocate for you and making sure you have the information On a prior broadcast, we talked about some of the things going on with regards to Hurricane Ian and the recovery efforts. We've talked about winter storms. We talked about many different things and reasons why you need an advocate on your side every single time you have a loss with your placing insurance, making sure that you're negotiating the best possible product as well as recovery. Now, it's always really important that you continue to get the information you need, and that's what this show is all about. It's making sure that you have the information you use, and we continue to do that every single week. And we're going to have on an amazing guest here at the show, but our very own Rob Bowlby, and I want to get right to it because we have a long list of things that we want to talk about. So, hey, Rob, how's things in Texas there?
Things are wonderful in Texas. After several very cold months, spring is starting to get here, and just feels good in Texas. And as you noted, Dan, we spent last week with the Texas Association of Public Insurance Adjusters down in Austin lobbying for some pro-consumer legislation. We'll talk about that as we go through our interview. But I'm super excited to welcome my new friend, Daena Ramsey. Daena's with Shields Legal Group. Jim Shields and I go back to my banking days that we've talked about a lot on this show. And Daena's relatively new to the Shields Legal Group. So let's start with you telling us a little bit about your background and about Shields Legal Group.
Thank you, and thank you for having me here. Shields Legal Group is a small law firm in North Dallas. We have an impressive transactional group, and on my side, we do litigation and trial, mostly for business and corporations, complex litigation. I have practiced. I'm just stopped at 30 years, so would you say over 30 years? I don't want to say it anymore.
Fair enough.
I own my own law firm for a while,
okay.
And have been trying to, after closing that, trying to find a place where to kind of spend the last 10 years of my practice before retiring. And Shields was a great law firm to go to. I've worked with them on and off for about 5 years, and I'm enjoying being there now.
Excellent. Well, so first of all, before I forget, Daena has cautioned me, like any good attorney should, that she is not giving legal advice today. This is purely an interview. But one of the reasons I was excited to have her is Daena actually has represented and continues to represent both sides of an insurance transaction. She still has several carriers that she represents. And then on the policyholder side, she represents several commercial property owners. And so I thought it would be really intriguing to let you talk about how you wear those two hats and kind of what it looks like to wear one hat versus what it looks like to do policyholder representation.
Yes, well, it's a little bit of a Jekyll and Hyde kind of thing because it is two different viewpoints. On the insurance side, we're trying to protect coverage and not spend money that they're not obligated legally to pay. It's a lot of contract disputes and just working over policy language and applying a policy language and negotiating with insureds and their public adjusters. Then you switch to the consumer side, whether a business or an individual, and it's more fun. a lot of times, frankly, because you get to be more of an advocate. And when I'm talking with the insurance company, I know as much or more than the attorney on the other side does about coverage and what's required and how to get the insured what they need. So, but I've moved off of a lot of insurance work and trying to move more toward representing the insured side.
You're like a stealth agent.
Yeah.
Yeah, for sure. No, I love it's really polarizing. So no, you need to know that stuff. So in your work, I'm sure you've come across public adjusters or other consumer advocates that are working on behalf of policyholders. Nowadays the policies are getting so much more complicated, right? There's so many more intricacies into it. There's a massive body of case law. There's common law changes that are happening, which I mentioned in the introduction, that are constantly changing, more so today than I've ever seen before, and I've been doing this over a decade now. Now you've seen it on both sides. Where have you seen the role of an advocate, whether a public adjuster or an attorney, benefit the policyholder?
When it's a good public adjuster who's competent and knows the policy provisions and knows how to navigate the system, the insured will come out ahead. I was around in the mold litigation days before public adjusters had to be competent and licensed, and it was a nightmare dealing with the very incompetent. They call themselves adjusters, and they were not. And now, when I can tell the difference between a really good public adjuster who is easy to work with and actually can get an insured more money than maybe the insurance company was willing to offer. There are things that an insured, especially in a large loss, it is so complicated. The insured has their own deadlines. They've got to start repairs. Their estimates have to be good. We would have unlicensed public adjusters who would submit estimates to replace a linoleum floor with hand-scraped wood. Well, right then you lose credibility. But if you have a public adjuster who knows good contractors, who knows how to work an estimate to the insured's advantage, the insured's going to end up with a higher return because they're credible. And if you can't respond to it and you're giving them an estimate that makes sense and based on the market, a contractor who knows the market and how prices are escalating. We had a claim with a public adjuster a couple of years ago when the lumber prices started just skyrocketing. And that public adjuster got them another $400,000 for their house because of all the price escalations. Did their homework, got the market surveys, got invoices from the lumber contractors that an insured wouldn't even know where to begin, and already has a large loss, and that has an emotional impact. So this is their kind of an independent neutral third party who can maneuver the process for them and make them not have to go not only suffer the loss, but be able to negotiate competently with the insurance company and get them a much higher return.
Well, and I think in the example you just gave, what I think of is, most insurance company adjusters, they're managing tens, maybe hundreds, maybe 1,000 claims. They don't have the time nor the capacity to do the research you just described, to go out and get market value for lumber prices to say, hey, this is what it's costing today to restore these people back to pre-loss condition.
And I've seen many times in there, especially with the weather, now we're getting into the spring weather, I have adjusters who, like you say, have 100 plus claims, or some of them are having to go out of state. And when they receive a package where they don't have to do the work, and they read the package, it's based on Xactimate, the program everybody uses, but it's they may have found different areas that the adjuster missed. And the adjuster sees that and he's like, well, I missed that. And it respects you.
Right.
And respects the estimate, then you're going to get that recovery.
Right.
But an insured is not going to be able to do that.
Yeah. Let's talk about freezes. Texas has been frozen every year for I think at least the past 3 years. Obviously, the largest one was the 2020 freeze, which I think you can tell us some stories of litigation you're still involved in from the 2020 freeze. But a mild freeze in 21, a pretty substantial freeze on the 23rd and 24th, right before Christmas, where when many policyholders were out of town or offices were closed. And so we've seen quite an uptick in activity related to the freeze this year. But talk to us a little bit about what policyholders need to be concerned about as far as freeze and water damage, and what do they need to be thinking about as they bind coverage?
Coverage. I'm in litigation. I have a lot of lawsuits going on right now out of the 2020 freeze because the statute of limitations is just about expired. Depending on the denial or payment of the claim, it's 2 years and a day. So that's another thing insurers may not realize, is that the policy insurers are allowed to reduce the statute of limitations to 2 years instead of normally it would be 4
right.
years. So we're seeing the 2020 freeze lawsuits now, and many insureds were shocked to find that they had no coverage at all. Many people do. But most of the coverage is written by endorsement. And so you get back to the complex policies. So I have a case where it took me 2 hours to sit through the policy and cross out the language that had been amended by endorsement. And I've got notes, yellow highlighting, cross-outs, and then the attached endorsements to try to figure out what the coverage was. And what they're finding out is I didn't get pipe burst coverage, or I didn't get water damage, or my limit is $1,500 or $5,000.
Yeah, that's the catch right there. I got water damage coverage,
yes,
and then
here's your $1,500.
It's $1,500,
and it's you feel bad, but if you're paying less than $1,000 for insurance coverage on a $250,000 plus home, you don't have a lot of coverage. So you start with having an agent who can walk you through the process, but it is more expensive now.
That's right.
So they were able to, especially after all the mold litigation and finding out that mold is not covered under normal policies, and then water damage and what is and not covered, and it's so expensive to repair a house that's been flooded, that they've moved to the endorsements. So you have to be careful that your regular policy may not cover it, and you've got to go see what other the options. You should be presented multiple options of the type of coverage for water damage, not to limit water damage, whether you're going to have mold and remediation coverage. But unfortunately, the most expensive losses are the ones that are harder to get coverage for.
That's right.
So Rob, you're up in obviously dealing with legislation session. January 10th, and I know there's a lot of talk about surplus lines insurers and issues and policyholders, and I know in Florida we deal with a lot of that, right? With the surplus lines insurers, you guys are talking about commercial policy forms, and obviously getting into some policy language and considerations and some of the tipping points for some of these lawsuits. What are some of the bills and related issues moving through the legislation process right now, and what are you guys concerned about?
Well, so first of all, thankfully, we're not dealing with anything like you guys are dealing with in Florida. So I'm grateful for that, but I'm also very cognizant that what happens in Florida generally starts filtering out into other states. So whatever insurance legislation gets passed in Florida, then every other state says, I'd like to pursue that as well. The two big things we're focused on in Texas from a insurance adjusting side is both, as you mentioned, Dan, with the surplus lines carriers. The first one is they have tried to insert policy language that says we will lower your premium if you waive your right to hire a public adjuster. I'm sure when presented with policies, and I don't know what the difference in premium is, but people think, oh yeah, sure, insurance company's going to treat me well, I'll go ahead and sign off on that. So we call it preserving the policyholder's right to contract. So that's one that we are supporting, to put legislation in place that prohibits that language being put into policies. The other issue is something that I know has occurred in Florida before. Surplus lines say, well, if this case goes to arbitration, which is another means of settling an insurance claim, arbitration is going to take place in New York or California or, God forbid, London. And if that's the case, then your policyholder frequently would have to travel there and or engage counsel that's licensed in that jurisdiction. And so one of the bills making its way through, this one's coming through the Senate, not through the House, is that arbitration for property losses in Texas can only occur in Texas. And we are obviously, along with the Texas Association of Public Insurance Adjusters, in favor of that as well. One thing that's not coming through right now that I think will probably be in the 2025 session, Texas's legislature only meets every other year, not annually, is appraisal. Insurance companies tend to hate appraisal because they tend to pay more money in appraisal. So they're trying to get those clauses either removed or put some guardrails around them. And there's an agency in Texas, not the Texas Department of Insurance, but the Office of Public Insurance Counsel, OPIC. They are starting to write recommendations to help preserve the appraisal process in Texas. You want to talk about appraisal or anything else you want to talk about with the Texas legislature?
Yeah, the appraisal process is it's complicated. The Texas Supreme Court recently, in lawyer terms, handed down 3 cases on appraisals that finally resolved. I mean, it took about 10 plus years to resolve the disputes over appraisals and the recovery for insureds for penalties for late payment. But it is the one thing that's kind of hanging out there with appraisals is when is it appropriate? Like on behalf of the insurance company, if we deny coverage, we're not going to go through appraisal.
Exactly.
Because there's no point as far as we're concerned.
Right. And if you're a good advocate, you shouldn't be invoking appraisal. It's a coverage issue, not a value issue.
Right. But I can see, and the insurance companies I represent, we actually don't always oppose appraisal. And I'm an advocate of it when there truly is a dispute over what it costs. It is significantly cheaper than litigation.
Correct.
It is the public adjuster can be involved. They don't have to be a lawyer.
Correct.
And it's a and it's faster, and it can be a collaborative process most of the time. There's some where it doesn't work out that way, and the insurance company is stuck with their name, whatever the number is, and so is the insured. Sometimes it is lower than what you're expecting, but it is to me, I strongly believe in it in cases where we're truly having a hard time resolving the cost of repair or replace and ACV versus RCV and how to, get through the process and get the insured the money quickly. It is anything that's better, anything that you can do that's better than litigation, really, truly, to resolve claims outside of the courthouse.
Yeah, we agree with that. So we're policyholder advocates, right. And so we always look at things through the view of just common sense. Like, let's be fair to these people. Let's they've paid you this premium for many years. Let's make them whole. And so for us, in my mind, the burden of proof should be in the insurance company because these people have paid you a premium forever. You have a duty to protect them. I think the reality is a little different under Texas law.
And I'm sorry I was laughing because I've seen that in every petition that's ever been filed. The insurance policy is a contract, and it's governed basically by contract law. You get what you pay for, nothing else. So the insureds are often very surprised to find out that they have the burden of proof. The policyholder has the burden under the law and under their contract to present a covered loss under their deductible. The insurance company doesn't have to do anything until that happens. Now, a lot of insurance companies, especially some of the ones I've worked for, will help you get through that process once you make a claim. And they'll go and inspect, they have deadlines to inspect and to work toward trying to find coverage if it's there. But if it's not there, it doesn't matter if you've paid premiums for 20 years. You either have coverage or you don't.
Right. It
either costs $5,000 or $10,000 or $20,000, whatever it costs. And that's the only thing that counts. But I have never been shocked when an insured, the first thing out of their mouth is, but you insurance company have to pay me.
Right.
I made a claim. And that's just the beginning. That's not even close to the ending. And I know it's frustrating for insureds when they realize that, but they do have the burden of coverage. And the insurance company has a burden to prove an exclusion. So if they don't want to cover it because it's listed on one of the exclusions, again, which what makes policies so difficult to understand sometimes, is you have coverage and then you have a long list of exclusions. We will cover this except this. when
Correct.
this happens.
And then they have to prove the
Then
exclusion.
they have to prove that. But then the insured has duties to timely repair, to provide estimates. If you disagree with the insurance company's estimates, you have a duty to provide your own
Okay.
in response and argue it. And it is a frustrating process.
Well, and I think going back to our earlier discussion about advocacy, that's where the advocate comes in to help build the proof. Like if the burden of proof is on the insured, a lot of times, to your point on the emotional toll it takes on the policyholder, you kind of get them lined up. Let's build that burden of proof, and let's make sure all the timeline. I mean, I think you kind of touched very briefly on the timelines, but the timelines are incredibly important, especially under Texas law.
Oh man, for the insurance company, they've got 15 days to get back to you. So, and the insured though has to cooperate in allowing them to get to that 15 days. Typically, and a lot of times in a big storm, they'll just pay the claim and not come out because they don't have time. Weather-related claims, the insurance company does get extended time. But it is a short time to either tell you have coverage, you don't have coverage, or I need more time to come out and inspect. And then the insured has deadlines to repair, because there's actual cash value and replacement cost. So you have to, and that's something else a public adjuster helps an insured with is I throw out ACV and RCV, and the poor insured is like, I have no idea what you're talking about. It's like you can't.
That's right.
Yeah, you don't. Some of the money owed to you is withheld until you repair, and then you get the rest of the money back.
Right.
And that's a navigation too of when you get that second, because you have contractors who want to be paid, but the insurance company is holding
back
the recoverable depreciation. And the insured's like, I don't even know what you're talking about. So just give me my money.
Well, and the other thing that we run up against a lot is, particularly if it's a contentious claim, if it really takes you some time to build your burden of proof, you either get an underpayment or denial, and then you go back, and then you finally, 4 to 6 months settle. And then you've only got 365 days under the policy from the date of loss to complete the improvements. Then all of a sudden there's a gun to your policyholder's head to get the work done. And that's probably easing a little bit with, housing being a little bit slower and commercial construction slowing down a little bit, less so in North Texas than in the rest of the country. But, there was a time you couldn't get stuff done in 6 months.
Yes. And the insured reads that and they think, I can't get a contractor to come out. So then you are able to communicate with the insurance company to extend that deadline.
That's right.
So after the pandemic, when there's such a shortage of contractors, they couldn't get people out.
Right.
You just can't get a contractor. And sometimes we are wanting to extend deadlines because lumber got so expensive. It was just, can we wait and see if it becomes less than the price of gold to reframe your house? That can be negotiated in writing.
Good.
Always get that in writing. But it is a tough burden on the insured because they want to move this along and get the claims paid and closed.
Yeah, that's exactly right.
Well, Daena, I wanted to ask you also about some of the important deadlines. I think there's been a lot of questions that we have fielded from policyholders, particularly after the freeze claims that you've had in Texas and Hurricane Ian that we had here in Florida. What are the top, I would say, couple time frames that you believe policyholders should be most aware of when filing an actual insurance claim?
That their insurance, well, not in a weather claim, but in a normal claim, that the insurance company has 15 days to respond and 30 days if it's a weather. So they have the right to have an immediate response from their insurance company. But also, if their insurance company asks them for additional information, then the deadline stops. Everything stops until the insured complies. And I've had insureds not respond for months, and they don't realize nothing's going to happen until they respond.
Truly, that's
nothing is going to happen.
Yeah,
I request for information or documents.
The thing is, I talk to policyholders all the time, trying to explain to them these constructs of these policies and their contractual obligations and the time periods from when they make notice of a claim to the getting the recovery to filing proofs of loss to issuing a sort of dispute, to how important it is. And you heard it right there from Daena. And there's on the other side of it, which is the insurance company's legal obligation under the common law, but also under the contract as to what they're supposed to be doing. And it's all very, very important. issues that you definitely need to be aware of, particularly as a policyholder. And as Daena mentioned, and something I want to reiterate, the difference between something like a weather event from a pipe break or one of your other types of losses. Weather events, they have an extended period of time in Texas. And so it's something very much to be aware of. You should be diarying these things. We've talked about some of the things that you should be doing in the, when you get into these different seasons and actually managing claims. Get a diary, start writing these things down, document the date, the time when you had that first contact to when something might be due or owed. Look at the contract. I know policies are boring as hell, but spend the time to take a look at these things, understand the processes. We have these cheat sheets. We've created all these things that we distribute on a regular basis to all our clients. But there's so much really important information that you need to be collecting during the claims process, and why an advocate can help you through that and make sure that those things are actually being documented and being done for you. So Rob, I know we're getting a little long here. I want to make sure that we've covered all the topics. There was something about maritime and your experience. I want to make sure that we hit on that.
Everyone focuses on that because we're in landlocked Dallas with a maritime lawyer. So there is actually Lake Texoma is a navigable waterway. So I've had a lot of litigation.
I forgot about that.
And I actually had a case. I didn't have to follow through with it. Having to do with a tributary that ran down to the Gulf of Mexico and joined a lake. So, but I had a client unhappy with their maritime lawyer and asked me to pick up a claim. And then a co-defendant was insured by the same insurance company, called up my insurance company and said, I want her. So that started
so you became a maritime attorney.
I'm like,
on the fly.
Okay. My first deposition involving a shipping incident, and the whole issue is whether the fire started on the port or the starboard. Well, I drew a little picture of a boat with a bow, and I had to write port and starboard so I could remember which one was left and which one was right. So 20
awesome.
years later, I'm a maritime lawyer.
Yeah, who'd have thought? Okay, well, in closing, Daena, tell us where people can find you, find Shields Legal Group. How do we get in touch with you?
Well, thanks to the spelling of my name, I'm easy to find on the internet. We obviously we have a website that is actually in production for being revised.
Excellent.
With providing even more information. We have blogs and connections to articles. But you look Shields Legal Group on our website. We're up in North Dallas.
Okay. Well, Dan, thanks as always for giving us some time here in Texas. It's always good to see you.
Well, guys, that was awesome. Great interview. Great opportunity to talk with an industry leader. Clearly, Daena is incredibly full of amazing information. We encourage you to go check out their website, reach out to them, let them know what they can do to help you. Obviously, in a situation, disputed issue, certainly more than competent to be able to help you navigate that. Having that experience on both sides, I can't tell you how important that is. Someone that understands how the insurance company is going to be thinking can help you get these things resolved. While sometimes we're looking for blood, that's not going to help you get paid. We want to make sure that we take the emotion out of it and we look at these things as a contract, because it is a business transaction. They sold you a product. You're just trying to get them to perform and do their duties and pay you for your damages if you're entitled to recovery. And as Daena mentioned, having a good advocate on your side early on in the process can help you navigate these tough waters. As a maritime lawyer, she understands how tough those waters can be. And as a policy advocate, she has certainly been through it on both sides of it. She's seen the arguments from the insurance company. She's seen the arguments, obviously, from the policyholders. She's analyzing those things. So great to have on. Someone with so much knowledge that have to share. It's awesome to have on our very own Rob Bowlby, talk about some of the things going on in legislation that are going to be impacting U.S. policyholders. So continue to tune in right here on the Recovery Report Live. As I always mention, if you haven't hit that subscribe button on YouTube or liked us or follow us on all the other social media, please go ahead and do it. We want to continue to provide you information you can use. And we'll see you right here next week, same time, same place on the Recovery Report Live.